Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, can I put my company into liquidation without having to declare bankruptcy personally? The answer to this question is that it depends on the circumstances for each company and person, but legally it is possible to put a company into liquidation without the director having to declare bankruptcy personally. The next question that typically follows is, what are those circumstances that would mean otherwise, as in that would tie the two together? That means that the director might be at risk of having to declare bankruptcy personally. There are two main situations. The first is if the director has signed any personal guarantees of the company's debts that the director is not able to pay. So let me explain this a little bit further. When a director personally guarantees the company's debts, it means that if the company can't pay, the director has agreed to personally pay the company's debts. Personal guarantees are typically seen in a range of agreements, including landlord premises leases, motor vehicle finance, equipment finance, banking facilities, and some supplier arrangements. Now, if there is a personal guarantee in place and the company goes into liquidation, this shifts the pressure to pay from the company to the individual. So in some cases, this might not actually solve the problem because it just moves the pressure to pay rather than solving the pressure itself. The other main circumstance that we see is around what's called ATO director penalty notices, or DPNs. If the ATO issues a director with a DPN, if certain criteria are met, the director can become personally liable for the company's debts to the ATO. Now, what can be done if a director thinks they've either signed a personal guarantee or received a DPN? Now, of course, if there is the ability to pay, that can be paid, and in that case, because the debt is paid, the person doesn't need to go into bankruptcy. However, practically, usually that's not a possibility because usually there's a shortage of funds all around. Now, if the debt can be negotiated so that it can be reduced in some way and some payment arrangement entered into, that is a possibility. And if it's a DPN received from the ATO, for the director to take whatever steps are on there, that avoids personal liability if that is an option on their particular DPN. Now, from here it gets much more complicated and specific to an individual set of circumstances. So definitely get professional advice if you think it's going down this road. But that's the highlight and overview, and the short answer to that question is yes, you can put a company into liquidation without the director having to go bankrupt personally if the situation and circumstances permit.